like to hear
May
you.
it please your lordship, my lord, I'm very much obliged for this opportunity to address you, my lord. I would have really been delighted if I was there physically, but my lord, there are all sorts of constraints. Otherwise, I would have not.
I know we would
It's
also
only
have liked
because
you to be
of your,
present here, but then
no, it's only because of your indulgence that you are, my lord, able
something
to
is
give me
something
an
is better than
audience.
nothing.
My lord, my lord, the point that the learned solicitor has raised, my lord, is important. I'm not saying it's not important. The questions that have been framed are also important because they would have a bearing ultimately on something to be decided, in this case, affecting the Sayedna judgment. There's no doubt about it. It would be so. But the point only is, my lord, today you have a writ petition of 1986 between a petitioner, the state, which is now redundant because the state was to support the act, but the act is repealed, and a private individual. Now, my lord, a tenor of decisions have said that such a writ petition is not maintainable at all. Now, whether you decide it now, you decide it later, you decide it after 9 judges, but at some point of time, that decision will have to be done in a pending matter, because that is the only matter before you, containing a whole bundle of facts, a whole set of denials, lot of affidavits, which I'm not bothering you with. Therefore, my lord, the question certainly can be referred, but nothing survives today in this petition, and that's for your consideration. Because although the act is repealed, the question of my right to excommunicate and the challenge to that survives, does not enable the present writ petitioner to move under 32. That's for your lordship's consideration. There are judgments of your lordships specifically saying between private parties there cannot be an enforcement of the writ. Now, that's one of the considerations, whether you take it up now, whether you take, I'm not at the moment trying to short circuit anything, but take it up now, take it up later, but that question does arise, and it will arise later. And there is one solution to this, perhaps, following what the solicitor says, namely, in the Sabrimala case, it was contended by before one of the dissenting judges, Justice Chandrachud, just as Mr. Nariman dissented, Justice Chandrachud also dissented. And the justice that the Sayedna case should also be deferred. And his lordship said, if your lordship turns to the Sabrimala judgment at page 180, para 272, 2019 11 SCC, if you have got it with you, my lord.
Para 272 you are mentioning?
I'm obliged, my lord, at 180. This is the other dissent of Honorable Justice Chandrachud. And this lordship says, my lord, after discussing
Yes, you
it at
got
the
it.
bottom, just before 273,
This is
Yes.
the
concurring, not
decision
dissent.
in Saifuddin, he calls it Saifuddin, is the Sayedna case, is presently pending consideration before a larger bench. That is your lordship.
Yes.
Because this comes subsequent to the 5-judge bench judgment, my lord, which said that if you are convinced that the law laid down is wrong, then you refer it to Sir Lahoti's judgment. So, my lords, quite frankly, this was all considered by the judges. It's not as if it's only it happens to be the other dissenting judge refers to it.
But in this opinion, Mr. Nariman, Justice Chandrachud's view was the
You
concurring
was
view.
just same as Justice Nariman.
So it was the majority view. In this one, it's the majority view.
Yes, it was the majority view, same as Justice Nariman and same as Chief Justice Deepak Mishra.
Concurring majority view.
This is the concurring
Yes.
majority view, 4:1, which went.
Absolutely correct. It's only Honorable Justice Indu Malhotra who took the dissenting view, which ultimately Justice Gogoi Malhotra thought was the correct view, and ultimately all those questions are
Everything is
raised.
gone to yes.
So there is no doubt these questions, the questions as framed by the 9-judge bench, I can't get away from it. It requires to be considered, and it will possibly be considered in God's good time. But today, my lord, we are faced with this problem. There's no question of referring anything.